Hi, I'm Carrie Baker. I teach in the program for the study of women and gender at Smith College. Thank you for joining me today for my talk on the ongoing battle for the Equal Rights Amendment. I teach and research women's rights law and policy and feminist social movements. My first book was about the women's movement against sexual harassment in the 1970s and 1980s. My second book was about activism over the last 50 years to fight child prostitution in the United States. And just last month, I published a co-authored law school textbook on sexual harassment law. My next book will be on reproductive rights and justice. I'm also a regular writer for Ms. Magazine. Today's talk on the ERA is based on an article I just published in the spring issue of Ms. 100 years ago, shortly after ratification of the 19th Amendment, suffragist Alice Paul authored the Equal Rights Amendment, which was first introduced in Congress in 1923. The amendment read, "Men and women shall have equal rights throughout the United States and in every place subject to its jurisdiction." An ERA with varying language was introduced into Congress every year after, until 49 years later, under intense pressure from the women's movement, Congress finally passed the amendment. The text of the ERA that Congress passed in 1972 read, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex." Note that the language of the ERA in 1972 is much narrower than Alice Paul's original language. I recently wrote an article on Ms. Magazine on the half-century campaign to win ratification of the ERA. Today, I'll tell you this dramatic story, including how the current administration in Washington is trying to block recognition of the ERA. Earlier this year, on the afternoon of January 15th, hundreds of women packed the gallery of the Virginia House as delegates voted on whether to ratify the Equal Rights Amendment and make Virginia the 38th and final state needed to enshrine the ERA in the U.S. Constitution. When House Speaker Eileen Filler Corn, the first female and first Jewish Speaker of the House in Virginia, announced a 59-41 vote in favor of ratification, the women in the gallery erupted in cheers, waving their arms and hugging each other. Delegate Hala Ayala declared, "Today is a major victory for women and girls throughout the country." Delegate Ayala co-sponsored the ERA ratification bill, along with chief sponsor delegate Jennifer Carroll Foy, both women of color elected for the first time in 2017. For decades, Republican leadership had blocked the ratification bill from a floor vote in the Virginia House. But in 2017, Democrats flipped 15 seats, decreasing the Republicans' 66-34 majority to a razor-thin 51-49 margin. Then in 2019, Democrats, backed by tremendous get-out-the-vote efforts by feminist groups, flipped the legislature and gained control of both the House and the Senate. As a result, women stepped into key leadership positions. Delegate Charneil Herring on the left became the first African-American and the first woman to be House Majority Leader. Delegate Eileen Filler Corn in the middle became the first woman speaker in the 400-year history of the Virginia House. Senator Louise Lucas became the first woman and first African-American president pro tempore of the Senate. The leadership made quick work of passing the ERA. By this vote, Virginia became the 38th and final state required to ratify the ERA and make it part of the United States Constitution. In fact, polls show massive public support for the ERA. The vast majority of respondents, men and women, Republicans, Democrats, and independents, want the ERA. Most think the ERA is already part of the Constitution, and nearly 2/3 believe that the ERA would have a positive impact for women. Despite widespread support for the ERA, the Trump administration and conservative state attorneys general are now trying to block recognition of the amendment. Donald Trump's Attorney General, William Barr, recently wrote a 38-page legal opinion arguing that the timeline for ratification expired in 1979, so recent ratifications were invalid. Hostile attorneys general from Alabama, Mississippi, and South Dakota have sued to prevent the Archivist of the United States from certifying that the conditions for ratification have been met. But Virginia Attorney General Mark Herring has condemned these efforts to block the ERA. He has said the Trump administration has concocted a scheme to try to nullify the will of millions of Americans. He's filed a civil suit along with the attorneys general from Nevada and Illinois, the 36th and 37th states respectively, to ratify the ERA. They argue that the timeline is invalid and that the executive branch, including Barr, has no role in the ratification of an amendment. Their suit demands that the archivist certify the amendment. Meanwhile, the U.S. House of Representatives took action on February 13th of this year. Under the leadership of Nancy Pelosi, the House approved a bipartisan resolution to recognize the ERA by extending a 1982 timeline for states to ratify the amendment. Yet despite some bipartisan support for the ERA in the Senate, Majority Leader Mitch McConnell is now blocking a vote on the resolution. The leadership needs to change, says Feminist Majority Foundation President Eleanor Smeal. During the 1970s and 1980s, Smeal was president of the National Organization for Women, which led the ERA fight. Smeal says that McConnell's refusal to allow a vote on the resolution echoes earlier fights for the ERA. When I interviewed Smeal for my Ms. Magazine article, she told me about a long history of obstruction, delay, and trickery. Back in the 1970s, when there were only 15 women in Congress, 2 in the Senate and 13 in the House, powerful male leaders of key House and Senate committees repeatedly blocked votes on the Equal Rights Amendment. The most powerful opposition, says Smeal, were business interests, especially the insurance industry, which opposed equality because sex discrimination is highly profitable. According to Smeal, women's equality is not just words. It means real things, especially in the area of money. It means you have to stop discriminating against women in employment and in annuities, life insurance, and health insurance. It involves billions and billions of dollars, says Smeal. Smeal told me, it was one hell of a fight. We marched, we picketed, we demonstrated. We had sit-ins. People were arrested. Some women went on hunger strikes. Every nonviolent protest that could be done was done. Now had a silent vigil on the steps of the Senate around the clock. Women's protests finally got the ERA out of committee in 1971, but with a 7-year ratification timeline in the preamble to the amendment. So the women's movement got to work, fighting tooth and nail to quickly win state ratifications. Hawaii ratified within hours of Congress approving the ERA, and other states soon followed. In many states, however, business interests and elected state legislators, overwhelmingly men, blocked the ERA from a vote, like in Illinois. By the end of the 7-year timeline, the amendment fell 3 states short of ratification. Feminists went back to Congress to pass an extension of the timeline. They had to fight hard to get it, but they prevailed, winning an extension until 1982. But unfortunately, no additional states voted to ratify the ERA. Until recently. After Trump took over the White House, the fight for the ERA became more urgent. The Trump administration began a massive rollback of women's legal rights on issues such as equal pay, access to contraception, and sexual assault. Then Trump appointed arch-conservatives Neil Gorsuch and Brett Kavanaugh to the US Supreme Court, which made it clearer than ever that women need explicit protection for their equal rights in the US Constitution. Feminists turned with laser focus to a three-state strategy. They sought 3 more states to ratify the amendment and then a congressional joint resolution to remove the timeline. The strategy was inspired by the ratification of the 27th Amendment, which related to salaries for members of Congress. Congress had originally approved this amendment in 1789. After Michigan became the 38th state to ratify the 27th Amendment in 1992, Congress passed a joint resolution agreeing that the amendment was validly ratified. But as feminists sought 3 more state ratifications, mostly male conservative leaders in state legislatures once again refused to allow the EU out of committee. So feminists focused on electing more women into office to blue. In Nevada, with the election of a record number of women and people of color in 2016, Democrats took control of the legislature. Under the leadership of the amazing state senator, Pat Spearman, the new Democratic majority ratified the ERA in 2017. Then in spring of 2018, Illinois finally ratified the ERA after strong pro-ERA movement activists succeeded in pressuring the Democratic speaker to allow a vote on the amendment. Weeks after Virginia's ratification in January of this year, State Attorneys General Kwame Raoul of Illinois, Mark Herring of Virginia, and Aaron Ford of Nevada filed suit to ensure that the Equal Rights Amendment would be added to the Constitution and that their state ratifications would be recognized. These 3 AGs argued that under Article 5 of the US Constitution, which sets out the process to amend the Constitution, a proposed constitutional amendment automatically becomes part of the US Constitution as soon as it is ratified by the legislatures of 3/4 of the states. Many constitutional law scholars agree. In my interview with Erwin Chemerinsky, Dean of UC Berkeley School of Law, he told me, Congress set the time limit, Congress can modify the timeline. He said that it's really important that the time limit was not in the text of the ERA itself. The time limit was part of a preamble before the text of the amendment. The amendment itself is ratified by the states. The preamble is not ratified by the states. If Congress can set the deadline in something other than the text of the amendment, why can't Congress change the deadline it set? They clearly can. I also interviewed constitutional law scholar and former dean of Stanford Law School, Kathleen Sullivan, who agreed that the timeline is not binding. Article 5 of the Constitution provides no barrier to Congress changing its mind, either eliminating or extending a deadline, she told me. And that's not a judicially reviewable decision, she said. That's a political question and not something that a court can come in and second guess. So if Congress were to pass a bill to remove the deadline, then that decision would be final and not reviewable by the courts. In the Constitution said that ratification must be synchronous, contemporaneous, or bounded within any particular time frame, she said. On February 11th, 20 state attorneys general wrote a letter in agreement. They called on Congress to remove the arbitrary timeline on the ERA and affirmed that the amendment is now part of the Constitution. Conservative state attorneys general, on the other hand, are arguing it has been too long since Congress passed the ERA, so Congress cannot extend the time deadline. That is decisively refuted by the history of the 27th Amendment, Sullivan told me. The 27th Amendment was proposed by the first Congress and ratified 2 centuries later. There's no Article 5 requirement that the states ratify in a particular period of time. The amendment should become effective upon the ratification of the 38th state. Opponents also argue against the ERA because 4 states, Idaho, Kentucky, Nebraska, and Tennessee have voted to rescind their ratifications of the amendment. And South Dakota stated its ratification would simply lapse after 1979. But historical precedent suggests that states cannot rescind their ratification of the amendment. After the Civil War, 2 states rescinded their ratification of the 14th Amendment, but Congress refused to recognize these rescissions. According to Chemerinsky, states that rescinded their ratification were counted toward the 3/4 of states necessary for ratification of the 14th Amendment. That indicates that the states that have rescinded can still be counted, he told me. Sullivan agrees. Article 5 speaks to ratification, but not rescission. Article 5 describes a one-way ratchet. It does not provide for a two-way ratchet for going in and out of the process. Ultimately, the Constitution and the Supreme Court precedent leave to Congress the questions of when an amendment is properly ratified, says Chemerinsky. If Congress, by joint resolution, says the ERA is part of the Constitution, then it is. Feminists are now focusing their efforts on the US Congress. The huge electoral victories for women and Democrats in the US House of Representatives in 2018 paved the way for advancing the ERA in Congress. Women were elected to a record 23% of House seats, and Democrats gained 41 seats, flipping control of the House to Democrats. In February of this year, U.S. Representative Jackie Speier from California introduced a joint resolution to remove the arbitrary timeline for the ERA. This is very simple, Speier said during the House floor debate. Women want to be equal, and we want it in the Constitution. Women of America are done with being second-class citizens. We are done being paid less for our work, done with being violated with impunity, done being discriminated against for our pregnancies, done being discriminated against simply because we are women. Under the new leadership of Speaker Nancy Pelosi from California, the House voted on February 13th to pass the joint resolution with a bipartisan 232 to 183 vote. 5 Republicans voted with Democrats in favor of the legislation. At a press conference ahead of the vote, Speaker Pelosi declared, "With this resolution, we take a giant step toward equality for women, progress for families, and a stronger America, because we know when women succeed, America succeeds." Our message here today is quite simple, added Speier, holding up a pocket-sized copy of the US Constitution. We want in. Attention then turned to the US Senate. Senators Ben Cardin of Maryland and Lisa Murkowski of Alaska introduced a ratification resolution in the Senate. In response to the Justice Department's opinion letter, they released a joint statement arguing that Congress certainly has the authority under Article 5 of the Constitution to set and change deadlines for the ratification of constitutional amendments, and has done so on numerous occasions. They wrote, "There is no reason to put a time limit on achieving equality of the law." But women once again encountered men's age-old strategy. Mitch McConnell is blocking a vote on the resolution. He says he's personally not a supporter of the ERA. Smeal believes that if there were a vote in the Senate, the resolution would pass, but McConnell won't let that happen. So to secure passage of the resolution, says Smeal, Democrats have to flip the Senate in the November election. You may wonder, why do we need the Equal Rights Amendment? I asked this question of Dean Chemerinsky. He said, sex discrimination has such a long history and tradition in the United States. Sexism is deeply ingrained in so much of our law as well as social practices. I think having the ERA in the Constitution really matters because it says we're rejecting that history of sex discrimination and sexism. Representative Spear says the ERA would have concrete impacts on women's lives. For those who question the need for the ERA, they need look no further than the gender wage gap that continues to keep women and families from achieving their full potential. Pregnancy discrimination that forces women out of the workplace. Persistent and insidious violations of the rights of survivors of gender-based violence, and much more. While the patchwork of constitutional and statutory provisions to provide some forms of sex discrimination, to prohibit some forms of sex discrimination in some circumstances, many of these provisions have been undermined, overturned, and even repealed, and all are subject to interpretation by the US Supreme Court. Until now, the Supreme Court has interpreted the 14th Amendment's Equal Protection Clause to provide limited equality protections against sex discrimination. But even these limited protections could easily be overturned by the Supreme Court. In fact, conservatives on the court have long disputed that the Equal Protection Clause provides any protections at all for women. In 2011, former Justice Antonin Scalia said in an interview that the Equal Protection Clause should not apply to women because it was never intended to do so in 1868 when it was adopted. He argued, "You do not need the Constitution to reflect the wishes of the current society. The only issue is whether it prohibits sex discrimination." It doesn't, he said. Nobody ever thought that that's what it meant. Nobody ever voted for that. If the current society wants to outlaw discrimination by sex, hey, we have things called legislatures, and they enact things called laws, he said sarcastically. The current majority on the court could easily follow Scalia's reasoning. 5 of the 9 Supreme Court justices are current or former members of the conservative Federalist Society, as was Scalia. The Federalist Society advocates originalism, or looking to the intent of the Constitution's authors for its meaning. Yet we know that the men drafting our country's founding documents were not concerned about women's rights, as evidenced by Abigail Adams' unheeded pleas to her husband, John, just months before he helped draft the Declaration of Independence, to please remember the ladies. He didn't. Women's rights should not depend on the current majority on the Supreme Court, Sullivan told me. We are the only major democracy in the entire world with a written constitution that does not have equal rights to protect women. That's a national embarrassment. It also has an unfortunate hole in our Constitution that leaves women's rights vulnerable to the shifting winds of the future judicial majorities in interpreting the 14th Amendment, says Sullivan. Federal laws prohibiting discrimination can also be weakened. Women have made numerous gains over the past 5 decades, from Title VII barring sex discrimination in employment to the Pregnancy Discrimination Act. From educational equity safeguards in Title IX to the Violence Against Women Act, and much more. But all these legislative gains can be wiped out by a hostile Congress or Supreme Court, or chipped away slowly and insidiously. A recent example is Trump's Education Secretary, Betsy DeVos's recent rollback of Title IX protections for students who are survivors of sexual harassment and assault in schools. An equal rights amendment, on the other hand, is forever. If our rights are in the Constitution, they can't be erased or rolled back by the changing political whims of legislators, judges, or occupants of the White House, says U.S. Representative Carolyn Maloney from New York, a leading advocate for the ERA in Congress. Women's equality will be spelled out in the Constitution, and it will spell ERA, she said. The ERA would give lawmakers the power to pass stronger laws to address sex discrimination and violence against women. In 2000, the Supreme Court invalidated an important provision of the Violence Against Women Act that allowed survivors of gendered violence to sue their attackers for damages because it ruled that Congress had no constitutional authority to enact the provision. According to Chemerinsky, The ERA would give Congress the authority to adopt laws to enforce equality. So that provision of the Violence Against Women Act would be more likely to be upheld under Congress's power under the ERA. According to Sullivan, the ERA clarifies that Congress has the power to enforce the amendment by enacting federal laws prohibiting sex discrimination that has gone unaddressed by the states. A new source of potentially powerful congressional authority against state lapses in protection against domestic violence, sexual assault, and unequal employment practices. The ERA could also help address the wage gap. The ERA would enable Congress systematic enforcement of equal rights, says Sullivan. For example, if women were being paid less than men for the same job, without that state anti-discrimination laws, the ERA could give Congress the power to predict what impact the ERA would have. We can just look at how state-level ERAs have helped win concrete change to secure women's rights. 25 states have passed their own ERAs, and several more are taking steps to enshrine women's equality in their state constitutions. On this map, states whose constitutions contain equal rights provisions are in blue. The yellow states of New York, Maine, and Minnesota have state-level ERAs in one house of the state legislature this past. Representative Lois Rick is heading the fight to pass the state ERA in Maine. Rep. Rickett was active in Now's 1970s ERA campaign and was one of Now's leaders in the 1980s. When I interviewed her about the ERA, she said, "It would give us the constitutional basis for equality, which would be much more secure than any of the minor pieces we have done. Only the ERA would establish the permanence of equality," Rickett said. She fears things like if the Affordable Care Act is overturned, the gender discrimination in health insurance will return because anything is reversible relatively easily unless it's embedded in the Constitution. Many states have interpreted their ERAs to provide stronger protections than the US Supreme Court has interpreted the 14th Amendment's Equal Protection Clause to provide. A majority of the state ERAs, for example, apply strict scrutiny to gender-based classifications in the law, a higher standard than currently applied at the federal level. That means that the government must prove that gender-based classifications are necessary to achieve a compelling government interest, and then they must be narrowly tailored to achieve that interest, a standard met only in exceptional instances like affirmative action. Some states apply an even stricter standard. Pennsylvania and Washington use an absolute standard under their ERAs, meaning that any gender-based classifications are presumed to be unconstitutional. And unlike the federal Equal Protection Clause, many state ERAs have invalidated so-called facially neutral laws that have a disproportionately negative impact on women and people of color, and laws based on biological differences like pregnancy discrimination. In addition, while the 14th Amendment only protects against discriminatory action by government, state actors, many state ERAs prohibit sex discrimination by private entities as well. The success of state ERAs in eliminating discriminatory laws is strong proof that a federal ERA will have real-world impact and women's lives better. So where do we go from here? We know that equality of women will always elude when it isn't etched into the Constitution, says Representative Maloney. We are in the final home stretch, the long-fought battle for the ERA, but the fate of the amendment rides on the fall elections. The ERA resolution is being blocked by McConnell and by the leadership of the Republican Party, Smeal told me. That's why we have to flip the Senate. It isn't individual Republicans. I believe if the ERA were put on the Senate floor, said Smeal, we would pass it. The problem is the leadership and whoever they are beholden to. We must flip the Senate to have leadership that will remove the time limit. Democrats need a net gain of 4 seats to win control of the Senate, and Smeal says they have a good chance in 6 states: Arizona, Colorado, Maine, North Carolina, Kansas, and Iowa. Like in Virginia, feminists have strong on-the-ground campaigns in these states and are using the ERA to motivate people to get out and vote. In Virginia in 2019, the ERA was on the ballot. It was one of the motivating reasons that people voted, says Smeal. She thinks that women's rights will be on the ballot in some key states this November. It will be the reason people will say, I've had it with these Republicans. I want equality for women. Supporters are also working to win additional ERA ratifications in the states such as Arizona and North Carolina. In Arizona, advocates are hoping to flip their state's legislature this November and bring the total of ratifications to 39. Arizona Senator Victoria Steele told me, "We are going to do in Arizona what Virginia just did. This year, all seats are up for election. We have turned purple and we're about to turn blue." Arizona advocates are using the ERA in the elections not only to flip the state legislature, but also to win a 2nd Senate seat for Democrats. It's a huge, huge issue, Steele says. They have fought us on the ERA at every turn, but we're not giving up. As Smeal says, it was never a matter of if, only when the ERA would be ratified. Women have fought long and hard for equal rights under the law and waited too long for full equality. It's time, long overdue, for the 38 states that have ratified the ERA to be recognized and for the ERA to be enshrined in the US Constitution. The days of women working twice as hard for half as much must end. Thank you for listening today. I encourage you to join Ms. Magazine to support our feminist reporting, rebelling, and truth-telling. You can read my work on msmagazine.com, and please follow me on Twitter and Instagram. In closing, I want to share with you a final quotation from Ellie Smeal that sums up everything so succinctly. Just think, guns have a constitutional amendment protecting them, but women don't. Thank you.